And good morning, Your Honor. James Gilbert here, acting as, the executor or trustee of the Marion Sherman estate.
Okay. All right. And this was a status conference for us to, we had adjourned this to allow the trustee to seek some guidance from the probate court with regard to any lapsed charitable gifts. What's the status of that?
We've had that hearing, Your Honor. There has been a beneficiary determined. I've been in contact with that beneficiary and then trying to put Mr. Kukuski and the beneficiary together. I'm assuming Mr. Kukuski is going to add him as a party, but now the ball's sort of in their court.
Okay, so what effect, Mr. Kukuski, for the plaintiffs, do you think that has on this case?
Well, I think, Your Honor, they need to be added as a third party to his complaint as a beneficiary now of the, I guess, ones that we're seeking portion of as well.
Okay. Here. I mean, I think it is, we certainly can't go forward without hearing from people that may have an interest as an identified beneficiary. But I wonder, I mean, the case has been pending for some time, and I was reviewing again the complaint in this matter. I mean, frankly, MCR 2.116 I1 directs the court that if the pleadings show that a party is entitled to judgment as a matter of law, the court shall render judgment without delay. And here the plaintiffs are suing a trustee based on a theory of third-party beneficiaries to promises allegedly made to other people that the funds would be set aside for them. But to whom the promise was made isn't the only issue here. Mr. Kukuski, I'd like you to articulate, is there any way in the world of the law that promise would be enforceable, even if it had been made directly to your clients? A gift is not a contract, so a third-party beneficiary is not a valid legal theory. The gift wasn't in writing, it wasn't delivered, it wasn't in the will or trust documents. If I were to enforce a verbal promise contrary to estate planning documents, I mean, that would throw the whole practice of estate planning on its head. You've sued on a third-party beneficiary to a contract, but this just so clearly isn't a contract. Why shouldn't I at this point trigger 2.116 I1?
Well, Your Honor, it's the timing of the promises as well as they, after making such promises, then went out and received.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At this point, the judge has shifted the entire direction of the hearing. The plaintiffs are arguing that heartfelt promises should be legally enforced, while the judge is asking a much tougher question. Can a verbal promise become an enforceable legal contract? That distinction could decide the entire case. Watch carefully, because the next exchange reveals whether emotion can overcome the written law or whether the law demands something far more concrete.
These stock beneficiaries or these stocks to benefit these two, their estate planning documents were already submitted and done. They were now living at the time in Florida as opposed to Michigan. I'm not sure what their thoughts were on making those adjustments to those documents, but certainly after making those statements, making those claims, saying that we're going to take care of these two girls, we're going to put things aside for them, buying these stocks to do so. The fact that it didn't get memorialized in their estate documents, I think, is the issue. But there was a promise under that claim, and that's what we're bringing the third-party beneficiary claim.
Right, but that's a gift, not a contract, right? Where's the consideration for that promise?
Well, because they were like grandchildren to them, Your Honor.
Yeah, well,
that was the statement as well, is that there's consideration as to their being family to these elderly individuals that have now passed away Their statements that you are like family to us, you've been there with us, you've taken care of us. We're making these, we're going to make, I guess, we're going to make things right with you. We're going to make things available for you and for your college tuition. And here's what they did after they made those statements, Your Honor.
All right, Mr. Gilbert, as the trustee defendant, what's your thought about that?
Well, I wholeheartedly believe that the Shermans did intend to put money away for these two young ladies. They verbally told me that they had. What I believe happened, and maybe this changes how the pleadings are gonna, is that there was a third party that intervened here, a guardian down in Florida, that cashed in the kids' CDs. From what I can tell, I think they were held wrong. I wasn't involved with that when the Shermans set these CDs up for these children. They were supposed to be there. The whole thing is the guardian, the person that took over the guardianship of them while they were alive, just couldn't liquidate the estate fast enough to get all their cash.
But isn't that still, I'm still just struggling with, this seems to be some, even assuming that those promises were made, it's a promise to make a testamentary gift. And so therefore a third party beneficiary and a contract theory wouldn't be applicable. And such a verbal promise wouldn't be enforceable, would it? I mean, it wasn't in writing, it wasn't delivered, it wasn't in any of the trust documents or will documents. And it would in fact run contrary to those documents. So why would allowing some verbal promise that was never implemented, not made to these claimants, why would a court allow that to be enforced without completely making estate planning documents because unreliable?
Well, see, where I think it was implemented. That's the problem, is that it was implemented.
Nobody's come forward with a CD that had their names on it.
Well,
then it wasn't implemented.
Well, there's stuff in the records that I had no involvement with, showing that there were CDs that were cashed, and but no identifying. And I have tried calling banks in the area down there to see if I could find copies, because I'm very confident that that was done. I mean, and what I think happened is we had a third party intervene and destroy the documentation or the CDs that were supposed to go to these children. And I'm basing that solely off of what I was told, how they, I was very close with these folks. Obviously that's the reason I'm the trustee, and I know what they intended.
This is where the courtroom becomes especially fascinating. The trustee is now suggesting that documents may have existed, but were allegedly lost or destroyed by a third party. That's a serious claim, but courts require evidence, not just belief or speculation. The judge isn't deciding what might have happened. He's deciding what can actually be proven under the law. What do you think? If someone genuinely intended to leave money for these children but never updated the legal documents, should their wishes still be honored, or should the written estate plan always control? Let us know your thoughts in the comments.
I'm not sure how somebody could cash out a CD with somebody else's name on it. So, I mean, presumably these claimants' names weren't on the CD.
Look, I'm not to interrupt your honor, but it could be held Mary and Ann Califer, and then the third party guardian that came in and was trying to liquidate. The whole thing down in Florida was kind of shady, what was happening down there.
And it was very expeditious, Your Honor. We did try to track the records and get more information about that. Those things were already done within maybe a month or less of these people's passing, and things were distributed. Money was given to the state. It was a very interesting proceeding down there in Florida, and expeditiously done.
Well, I mean, that's not even the claim that was made. I mean, I'm looking at a complaint for a third party beneficiary, which is a contract. This case is dragged on for quite some time for a trust that has been open for a very long time. I wanted to make sure that we identify a successor beneficiary, which through the probate court, the trustee has sought guidance and received. These are claims made by people that aren't beneficiaries of that trust, that the trustee denied those claims. And so the claimants have sued the trustee. I have some concern that we don't really have adverse parties between the plaintiff and defendant. The defendant trustee seems for the court to want to grant the the claim, but the trustee had denied the claim, presumably, because there's no legal basis for it. I mean, it's not in the trust. The complaint is for third-party beneficiary. That's just so legally unsustainable. Now that we have a trust, now that we have a beneficiary identified for this trust, I think it's incumbent on the trustee to implement that trust to that beneficiary. Under 2.116 I1, I find that these pleadings do clearly show that the defendant's entitled to judgment as a matter of law, and I should grant judgment without delay. So relying on that court rule on the court's own motion, I'm granting a judgment of no cause of action in favor of the defendant. The claim is denied by the court, and Mr. Gilbert, as the trustee, I'd expect you to file an order to that effect.
Yeah.
And, claimants can file an appeal if they want. I think this is so clearly the law, but maybe I'm wrong.
Thank you, Your Honor.
All right. And then I've got a pretrial in Hines v. Swadlin.
In the end, the judge concluded that the lawsuit could not survive because it relied on a legal theory that simply didn't fit the facts. The court emphasized that a verbal promise to make a future gift is not the same as a legally enforceable contract, especially when it conflicts with written estate planning documents. As a result, judgment was entered in favor of the trustee, although the claimants still have the right to appeal if they believe the ruling was legally incorrect. This case is a powerful reminder that good intentions alone are rarely enough in court. Proper legal documentation is often what makes the difference. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.